Okay, we're about finished. Director Adcock, go ahead, please.
Yes, Mr. Carpenter, we had a situation arise a few weeks ago concerning one of the candidates for City Board position number 2. And there has been lots of comments from the public about this. I've got lots of people calling, wanting to know why we will not do our job up here, because they perceive that we should have done something back when all this came up. And I know that you tried. In fact, one story in one of the newspapers even said that I was the vote that stopped it, which that's not true. But I would like for you to explain to the public what happened, how it's been handled, and what the outcome is going to be.
I'm going to give Director Richardson a point of personal privilege on this. He wanted to make a comment before Mr. Carpenter responds.
Yes, thank you, Mayor. I just point of clarification, Mayor Tom, since this involved me and it's a race I'm involved in, do I not need to recuse myself and leave the room with respect to any conversation on this issue? I know we're in an agenda meeting, but I have no preference one way or the other. I'm not going to change how I campaign, but with respect to protocol and legality, do I need to leave this room?
Director Richardson, under the city's code of ethics, any time that a board member feels that there is a problem, they're allowed to recuse.
Well, I will recuse on this, and I don't know if I need to. When I had a contract with the agency before, and whenever there was conversations involving that contract with that agency, I would leave the room. So I'm recusing from the conversation. I guess my question to you or the mayor or Bruce, do you guys think I need to leave the room for appearance's sake?
Director Richardson, the ordinance actually says you step down from the dais, but what has happened is people have typically left the room.
Thank you, Bruce. Tom.
Director Adcock, to answer your question, information was brought to my attention, I don't even remember the day now, but it questioned whether or not one candidate was qualified to be a candidate for a Ward 2 position. The reason for the question is that the address listed in the petitions to seek the office was in Ward 1 and was not in Ward 2. I reviewed the statutes at that time, and it became very clear that even a candidate has to be a resident of the ward that they wish to serve, and therefore this person was not qualified to go forward. This information was brought to the attention of the Pulaski County Election Commission, and we got an email from their attorney saying that since the city clerk certified the name forward, that they weren't going to do anything. They did not mention the statute that says that the commission has to certify the name to the county clerk in order for the ballots to be printed. They just said they weren't going to do anything. So then the question became, how do we deal with this situation? The short answer is that the only way you can deal with it is to file an action that has two parts. One is a petition for a writ of mandamus, which is to direct an action by a public official, and the other one is to simultaneously file an action for a declaratory judgment that the individual was not qualified. In doing more research for the situation, we found that on the state Secretary of State's website, the person is shown to be a resident of Ward 1, and that the voting registration for the individual was changed in May of this year in order to vote in Little Rock during the elections. And so as at that point they were at Ward 1, and that had not changed. There was information that the person had recently moved to an address that is in Ward 2, but that didn't mean that they were at that address at the time they filed their petitions, and therefore they were never legitimately a candidate. Arkansas, as you've heard from me, has an incredibly liberal FOI, which is very much in favor of disclosure. And because of some cases, basically out of Fort Smith, attorneys can't call governing body members and ask for permission to do something. So I have taken the stance that I call and say, this is what I'm going to do, or send a letter or an email and say, this is what I'm going to do, with the understanding that if anybody objects, then I'm not going to do it. It's because I can't poll a board. That would be a meeting and the press has to be called and everybody has to be present while I make the phone calls. I got objections from 2 people about filing the action. You were not one of them. And as a result of that, I did not proceed forward. And unless and until I get any direction, I can't.
Okay. And will you tell us what the outcome will be if no action is taken?
If no action is taken prior to the election to challenge the ballot position for this individual, if assuming that they still live in Ward 2, if they are elected, they would be allowed to serve.
Will that have any impact on our bonds or on any other legislation this board might pass in the next 4 years?
Director Hancock, I don't think so. That doesn't mean that somebody may not raise the issue, but I think I pretty thoroughly researched this issue, and this is the type of objection that has to be made prior to the election or it's waived.
Okay, thank you. I wanted this brought up, Mayor, because I'm hearing from people that this board is not doing our job, and I think that we all are very careful to make sure that we do our job and we do it in an honest and accountable way with the public. So thank you, Mr. Carpenter, for that.
All right, very good. Director Wyrick. You're next, please.
Okay, my